Hi, this is Jen Rubin, editor-in-chief of The Contrarian. I'm delighted to welcome for the first time Lisa Graves. Lisa is an author. She is the executive director of True North Research. She is also the co-founder of the Court Accountability Project. Welcome.
Thank you so much, Jen. Thanks for having me on.
Your book, Without Precedent, is so aptly titled and so aptly timed because, of course, one of the facets of this Supreme Court is that they seem to give very little weight to precedent. How extraordinary is that? How unusual is the degree to which they are willing to simply disregard and sometimes not even admit that they are reversing precedent as compared to other Supreme Courts?
I think it's very unusual. You have a U.S. Supreme Court now that has, in essence, been chosen to reverse key precedents of the 20th century and even to undo key laws passed by Congress. And so you have a court that I think is behaving very aggressively, and in fact, I would say arrogantly, in its zeal to basically, tear down all those trees, to take a page from a famous novel. And it has done so in some ways with such arrogance that it has been intervening, as you know, to overturn lower court ruling after lower court ruling, rulings that were based on detailed findings of fact and detailed applications of longstanding precedent or longstanding statutes. And yet this court, in many cases over the summer in the dark of night, has been willing to move heaven and earth to get rid of any barriers to key, and I would say novel claims being made by Donald Trump to allow him to proceed. And I'll just say one more thing about that, which is, as you know, and as I think many of your listeners know, the standard for a temporary restraining order is, substantial likelihood of success and likelihood of irreparable harm. And many of these actions have already caused irreparable harm. And the reason there's an opportunity to have a temporary restraining order until the matter is resolved is to try to prevent that type of irreparable harm. But instead, this court has allowed those harms to continue and pile up while the actual substantive merits are being argued. And so it is unprecedented to have a court behaving in this way, especially in this very short time frame over the last 12, 15, 18 months.
It is unusual that you have a argument that seems to be emanating from the court that irreparable harm is the president not getting to do whatever he wants to do, that they're
Yeah.
not willing to look at the individual harms, the state harms, locality harms, but Trump not getting his way is somehow an irreparable harm. That's a very unusual formulation that I've never seen before.
I've never seen that formulation either. I think that's a really astute observation. And I have wondered, in addition to the, court capture scheme that has been underway for the last couple of decades that has led to the advent of this Roberts Court, we now have so many justices, 5 of the 6 justices in that faction served in the executive branch. And so they've spent parts of their careers trying to expand executive branch power. Of course, when Biden was president and wanted to have a modest amount of student loan debt relief during the COVID emergency, that was verboten, that you needed congressional action. But now that there is a Republican president, Republican Congress, and I would say a Republican court, they are doing away with those sorts of real separation of powers, real checks and balances, and instead allowing this president to do things that are actually committed, in our Constitution to Congress, the
Right.
power of the purse, tariff issues, and more.
Absolutely. One of the things, the contrast we've seen between the lower courts and the Supreme Court is that the lower courts recognize that in certain areas, the president does enjoy deference. In my view, much, much too much deference, and it shouldn't have any deference to this president, but be that as it may. But in the words of Judge Emmergalt, who just ruled on Portland, deference doesn't mean ignoring the facts. And as she put it, the president is untethered to the facts. She could have said untethered to reality. That insistence that the president not be given unlimited discretion, unlimited deference, seems to be part and parcel of the Supreme Court and the courts in general retaining any role. Because if you simply defer on everything to the maximum extent and he can make up words and make up conditions, there is no check on the president. Am I missing something
You are not missing anything at all. And in fact, what we've seen a number of courts find is basically arguments of pretext, claims being made that are without fact, that are the opposite of the facts that witnesses have attested to, that people on the ground have attested to. And the other component of it is that in general, in our appellate process, the Supreme Court is supposed to defer to the factual findings of the courts
there? Yes.
below, because they are hearing witnesses, they are taking in those affidavits and examining what the facts are. And instead, we have a Roberts Court that has gone out of its way in this arena. And in other cases, we saw this with the football coach case a couple of years ago. We've seen it with the case involving the website firm, where this court is basically inventing facts, making claims about facts that aren't true. We saw it in the South Carolina redistricting case, and I could go on and on, but that's why, when I was writing this book last year, Without Precedent, I'm astonished by how much this court, this Roberts Court, is willing to disregard the law and the facts in order to reach the results that it wants, which I think are putting not just a thumb, but now a fist on the scale of justice in ways that really imperil all of our freedoms.
Absolutely. Some people say, well, maybe Roberts is trying to avoid a showdown with the president. And others say, well, maybe they just believe in a big executive and executive power. And others say, no, they're just a bunch of hacks and they're letting Trump do whatever he wants. Do you have a theory of kind of what's behind this? Why they are now seemingly handmaidens to a president who has huge, huge ambitions to, as he said, operate like a dictator?
Well, I think that you have a court that is behaving like no other Supreme Court has in U.S. history. There certainly have been a raft of bad decisions in the 19th century that we could name, including Dred Scott, but you haven't seen it happen on this sort of systematic basis and in ways that really are an offense to what I think a traditional conservative or someone who believes in those checks and balances would follow. We've seen the brilliant and insightful comments of Judge Ludwig, who is a noted conservative, who's talked about how this court needs to be a check on power. I don't buy the claim that Roberts is avoiding a conflict in order to maybe keep his powder dry for some future conflict, or so I just don't buy it. I think that he has been soaked in just the same sort of right-wing echo chamber as some of the other justices. He's just been a little bit more reserved in some of his public comments because his actions show a willingness to not just countenance, but rationalize and allow Donald Trump to get away with plain violations of the law, evidence that is mounting in a lot of different areas of just disregard for the law, and as you pointed out earlier, Jen, just a lack of tethering to the facts. And just 8 months ago, Roberts swore Trump in, on a Bible, pledging to faithfully execute the law, to defend our Constitution. And since then, we've seen not just a president transgress the law and transgress the plain language of the Constitution. We've seen John Roberts and the Roberts Court willing to go along with it, and even chastising, in the case of Neil Gorsuch, chastising lower court judges for not basically reading the tea leaves of what they didn't say about basically how the law doesn't really apply to Donald Trump.
And that's something else that strikes me as unique. One thing that distinguishes courts from legislatures or courts from executives is courts have to hear arguments, they have to air the issues, and they have to explain themselves in some cogent way. This court is bypassing all this and operating by edict as if they're the ultimate authority. We know statistically that there is no comparison in the number of emergency docket cases this court has operated on. Why do you think they've fallen into this pattern? And can they be convinced that this is not a good idea, or that it's leading to chaos in the courts below?
Well, the easiest thing for this court to have done this summer would have been just to let those lower court rulings stand. That would have taken almost no energy or action on their part. There was ruling after ruling, many of which were upheld expressly by the circuit courts, by the intermediate appellate courts. And the easiest thing that a court operating under judicial restraint or deference or a sense of caution about what's unfolding would have been to let those rulings stand. And instead, this court aggressively intervened in a way that is statistically anomalous, except for it's not anomalous if you view this as a hyper-partisan court engaged in hyper-partisan activity for a hyper-partisan president. That's what's happening, I think, in our country.
Absolutely. I don't know if you have ideas about court reform, but obviously we have gotten so far off track. There's a school of thought that says, oh, just wait for these guys to, die off, and other presidents will appoint replacements who may be more contained and more faithful to the Constitution. I'm not of that group. I tend to think there won't be anything left if we let these people run rampant. Congress does control the appellate jurisdiction of the court. It does control the number of people on the court. Do you have in mind reforms that could force a correction, or at least dilute the power of these particular justices?
I do, and in fact, in my new book, I talk about some of those proposals, which are both a set of court reform proposals as well as substantive proposals to restore the Voting Rights Act. For example, I do think that term limits is something that Congress should explore. I think the jurisdiction issues, limiting the court's jurisdiction, is also a possibility that should be fully explored. I think that expanding the court, my personal view, not my organizational view, but my personal view, is it should be 15 judges or more. Why not? And to
Right.
those who say, oh, then they'll just appoint 10 more. So what? I also think we need an intermediate appellate court between the Supreme Court and these other courts to handle the business of the American people. The fact is that even without these serious aberrations in the judicial function, meaning a court that's not acting like a court in following precedent, but a court that's acting like, a political body that's ratifying, a president. Even without that, we have a court that's receiving more than 8,000 petitions for review a year and accepting only 60 to 70 cases for argument. So the vast majority of cases are not resolved by the Supreme Court, but they're handpicking the ones they want to, like a political slate. And this question of whether Roberts, in essence, and his cohorts are ultimately doing away with the power of the court, I suppose, in essence, they're acting like a kingmaker. Their ruling last summer, the ruling that Roberts orchestrated, paved the way for Trump's return and sent a signal to a subset of the American people, that Trump did no wrong and could do no wrong. That was a very damaging message to send, especially because in America, no one is above the law, is supposed to be above the law. And Roberts himself pledged to the American people during the nomination that he agreed that no person is above the law, that no one is above the law under our system. And yet, when it mattered most, he violated that. So I think this court is in desperate need of reform, and we fail to reform it at our peril because it is on a year by year, month by month, and now week by week destructive path of empowering the evisceration of our freedoms and basic rules that require restraint from all, branches of the government, including checks, powerful, important checks on the executive branch.
I sometimes think that the worst jobs in America are the three women who constantly have to dissent on the Supreme Court. I don't know how they keep their sanity. There seems to be two schools of thought in how they pursue that. Um, Judge Jackson seems to be writing in a very accessible way, in using a lot of Calvin Ball, using a lot of terms that average people can understand, in a very plain spoken, almost I don't want to say aggressive, but blunt way, basically saying to the Supreme Court, you are faking it. You are
Yep.
not doing judging. You
Yep.
then have the other two justices who seem to take each case and then they destroy what the majority has done, but less willing to come forward. Do you have a feeling as to which is more effective, or whether you kind of need both? You need an inside game and an outside game.
I think you do need both, and I definitely I so appreciate all of their work. It's to me, it's in the vein of Earl Warren when he crafted that unanimous decision in Brown versus
Yes.
Board of Education. He wanted a ruling that every American could read and understand. That, for example, separate is inherently unequal. I think when these justices, these dissenters, write so plainly, or when they put the arguments into a more, case cite fashion, both of those should be widely distributed. They should be reprinted in full, in my view, or at least in significant part, in major newspapers and magazines. The American people should be having a conversation about them because they're telling the American people what's really happening. And when a judge does that, that shows like the warning bells are going off, like the red blinking lights are happening. This is not something that they would, I think, do if they did not feel strongly that this court was going off the rails or off the rails, and the American people needed to know. So I feel like their language, both putting it into that more case by case approach as you described it, and also putting it in the broader context for the popular understanding, both are so important for the legal profession also, which has been a bit asleep at the wheel. Sort of like
Yes.
this is this is just the swinging of the pendulum. This is not the swinging of the pendulum unless the pendulum is like a sharpened axe. You know, we're in a very dangerous moment, and we've been in a series of dangerous moments in our country that seem to be growing more dangerous almost by the day. And yet we do not have the response happening here within the legal profession and in some ways the broader community that other countries have responded to when their judges have spoken out, like in Poland, for example. So obviously, King's Day is coming up, and there's an effort to have a large nonviolent, passive, peaceful, musical, joyful protest in the face of what we're seeing. But I think we need people to understand from our perspective, ordinary people's perspective, but also quoting those justices because they are
Yes.
telling the truth. They are speaking truth to power from within the building, inside the
Absolutely.
house.
Absolutely. And to their credit, I have never seen as many outspoken lower court judges basically
Yeah.
telling the Supreme Court they're making it impossible to do their job, and they're making them look like fools because they got all the trouble of finding facts and researching the law, and then they're summarily overturned. I would also say it's extraordinary the number of former judges who have never engaged in any
Yep.
kind of public dialogue, but I think they're hitting the alarm bell. I think this is the break the glass moment.
Yep.
So it strikes me that if they recognize how really extreme things have gotten, the rest of us should as well. Well, I'm sure the book is going to be a tremendous hit. It is called Without Precedent by Lisa Graves, and we will look forward to it. And we'll look forward to seeing you out there at No King's Day. Thanks so much for joining us. We really appreciate it.
Thank you, Jen. Thank you so much. I am a contrarian.
Yes,
Thank
you
you.
are.
Thank you.